Thank you very much. Thank you for the invitation. Thank you for the introduction. It's a real honor to present my work. So let's get into it. So the first thing you'll see is I changed title. I seem to be completely incapable to stick with one title. So I added one that I think might be a little bit more indicative of what the presentation will be about, actually. So from When Control Attempts to Escape the Border, I think the new title would be Beyond the Border, Local Attempts to Exclude Immigrants Through Nuisance Laws, and that's in the U.S. context, so which might not be evident in the title. I first have also to say that I'm conducting this research with a colleague of mine in Los Angeles, Kathy Kolnick, who's based at USC. We published part of it, and we're still working on the other part of it, so consider this kind of work in progress. So your feedback will be very welcome. So 2006, I'm going to take you a little bit back to 2006. 2006 was a watershed year for immigration politics in the U.S. Millions of people marched in large cities to defend immigration rights and to oppose legislation criminalizing undocumented immigrants and to demand the regularization of undocumented immigrants already living in the U.S. On the other side of the debate, and at times literally on the other side of the street, Minutemen and other anti-illegal immigrant groups, frustrated by the inability of the federal government to control borders and to restrict immigration, set their watch predominantly on the U.S. and Mexico border and at day laborer sites in numerous cities. In Washington, both Congress and the House of Representatives more intensely than ever debated a comprehensive Immigration Reform Act and any permutation of such a reform. Field hearings on immigration reform were held in all parts of the country. George Bush, remember him, signed the Security Fence Act authorizing the construction of 700 miles of wall and fence along the U.S.-Mexico border and increasing border surveillance equipment and technology. I guess as Van Mueller had presented last time on Avatar, the Border Patrol loves their technology. Mainstream and independent media reported nonstop on the very polarized immigration debate day after day, and often furthering this polarization. State legislatures introduced hundreds of pieces of legislation concerning immigrants and related to education, employment, driver's license, and many other issues, and about 100 bills were signed into law in 32 states in that year alone. Municipalities also stepped into the debate with local immigration-related laws, and I would argue that the unprecedented action of small towns and counties USA really captured the populist attention to the debates of the so-called illegal immigration. As small communities started seeing more racialized immigrants, whether legal or illegal, because of course their status is not visible, they became nervous about their quality of life and defensive of their services, their values, and their territories. There were two types of local ordinances, one that I'm not concerned here today about, which was the pro-immigration ordinances that sought to reaffirm a status of sanctuary cities in support of comprehensive immigration reform, or refusing to check immigration status and calling for a moratorium on enforcement and employment rates. The other type, which is the object of this research, sought to introduce local anti-immigration ordinances, or illegal immigration relief acts, as they were called, by combining employment, housing, policing, and language restriction for immigrants settled or settling in their communities. Consistent to the spirit of anti-immigration legislative proposals, they also sought to extend penalties to anyone who help or enable illegal immigrants to enter and locate in their communities. So more than 100 immigration-related municipal ordinances were introduced or considered in small town, township, and counties in 31 different states in 2006 and 2007. So really it's mid-summer 2006 to mid-summer 2007. Local fear of illegal immigration was couched in the larger rhetoric of federal incapacity or unwillingness to tighten immigration laws and national borders. And that, of course, despite the militarization of the border. Although a reaction to the perceived failure of Washington to secure the U.S.-Mexico border, local anti-immigration ordinances were very much inscribed as the extension of the same national sovereignty and security regime. By localizing immigration enforcement efforts at the level of municipalities and neighborhoods, anti-immigration measures attempted to control the everyday practices of undocumented immigrants by restricting basic and public services, therefore forcing them to self-deport or at least relocate in another city. Local restrictionist measures sought to control, deter, and incapacitate the presence of immigrants by using municipal police power authority to regulate public health, safety, and welfare, that is the credo of urban planning and land use zoning, and to protect peace of residents. These local ordinances have had limited legislative success. They were all or in part ruled by courts as unconstitutional, but they had a tremendous impact on furthering the anti-immigrant sentiment at the local level by reinforcing the construction of the illegal and by extension all racialized immigrants as criminal. In this presentation, I examined the concept of public nuisance as the foundation of these local anti-immigration ordinances and of a subsequent strain of far more innocuous and difficult to detect local nuisance laws passed since 2007, so a second generation of legislation. Some of the same local governments that failed to implement their anti-illegal immigration laws in 2006 and early part of 2007 have since introduced, amended, or revived municipal nuisance laws, which, despite being which despite their neutral language about regulating undesirable activities in the public interest, promote a particular social order and are loaded with racialized connotations. In fact, both generations of local anti-immigration ordinances appear to have the exact same goal, which is to drive immigrants away and preferably across the border. By doing so, it also sends a clear message that new immigrants are not welcome in their communities. Briefly, because I will expand on this in the later part of the talk, the legal concept of public nuisance is generally used to describe a condition, activities, or a situation that unreasonably harm or interfere with the rights of the general public. Nuisance has been used by municipality to regulate private and public offenses such as material or visual blight, noise, air, water, or soil contamination. It has been traditionally used to regulate sanitation and health issues, but the elasticity of the concept has more recently encompassed claims to protect local quality of life and property based on value principle and aesthetic preferences. Even more recently, the concept has served as a label for pretty much all forms of progressive protests, whether it be the G20, well, the G20 protest, of course, not G20 itself, or Occupy protest. For power and people in power, that dissenting presence in the public sphere has become undesirable and thus public nuisance. Nuisance laws have been used legislatively and discursively to control and target specific population without necessarily having to name them. So I'm going to now talk about the first strain of local immigration-related laws. So those illegal immigration relief acts. So the first strain explicitly used the legally broad concept of public nuisance, to criminalize the presence of immigrants in their territories. So given this overt use of public nuisance in anti-illegal immigration relief acts that targeted residents on the basis of immigration status, the correlation with the next strain of nuisance ordinances in those same municipality of counties is, I believe, quite significant and probably not a coincidence. So local illegal immigration relief acts, ordinances, spread quickly across the country in summer 2006. They were based on a common template allegedly prepared and promoted by FAIR, by the Federation for American Immigration Reform. Of course, not all small-town USA consider such ordinances, but those who did, the copycat ordinance model made too clear reference to public nuisance in their section 2. And using one of the most famous cases, here you have the text of the Hazleton ordinance, which says that illegal aliens harm the health, safety, and welfare of authorized U.S. workers and legal residents, and that the city has a duty, and in fact it is its responsibility and due diligence to abate public nuisance, and specifically to abate the nuisance of illegal immigration. The next slides are about the different type of ordinances and the different towns that adopted or consider or table them. Local anti-illegal immigration ordinances generally sought to discourage and incapacitate the residency of illegal immigrants by decrying English as an official language, eradicating gathering places for day laborers, forcing landlords to verify the immigration status of potential renters, restricting hiring practices and access of services beyond federal standards, and establishing registration policies. In doing so, they intended to make enforcement agents out of local landlords, employers, municipal clerks, and police, all of whom had no training in immigration law and no or very little accountability. Local ordinances endeavored to give local state government and non-government actors control powers over illegal immigrants' everyday space and encounters by apprehending them and forcing them out of their communities. In a climate of conflation of immigration control and terrorism, anti-illegal immigration ordinances sought to reproduce the post-9/11 security regime that has increased and the increased securitization of immigration by Homeland and Security away from the border into the small towns and neighborhoods. While municipalities have indeed the police power to abate public nuisance, the particular rationality of being empowered and mandated to abate the nuisance of illegal immigrations has been flatly rejected by different courts. Local anti-illegal immigration ordinances were taken to courts by, I'm one slide behind, I'm sorry. So local anti-illegal immigration ordinances were taken to courts by immigrants and human rights activists. The unconstitutionality of the local ordinances was clearly expressed in the case of Lozano versus City of Hazleton. Because federal law preempts these ordinances, Judge James Mundley concluded that through its numerous anti-immigration ordinances, the City of Hazleton violates the procedural due process protection of the 14th Amendment of the U.S. Constitution, and therefore enacting unconstitutional laws was ruled beyond the defendant's police power. Hazleton was permanently enjoined from enforcing its ordinances by the courts, first in 2007 and again in 2010. Hazleton became the test case for many other small towns who all awaited the court's decision before pursuing their own anti-immigrant agendas. A few other municipalities also took their matter to courts, but the result was the same federal preemption and unconstitutionality ruling. The courts reiterated the regulatory authority over immigration controls as solely concentrated at the federal level. Some cities, like Hazleton, appeal court rulings, but most small towns did not have the human or material resources or financial resources to engage in long and costly legal battles. So abating public nuisance, yes, because cities possess the police powers and that they can enact legislation to promote public health, safety, and general welfare, but as long as such legislation does not violate fundamental rights enshrined in the U.S. Constitution. However, controlling and punishing illegal immigrants? No. And considering illegal immigration as public nuisance? Well, not so clear. Because, interestingly, the discriminatory motive behind local ordinances, or more specifically, the discriminatory nature of the ordinances on the basis of race, ethnicity, or national origin of immigrants, were dismissed by the courts under the same arguments of constitutional protection. So, proponents of anti-immigration ordinances, among others, Hazleton former mayor and now U.S. Representative Lou Barletta, and Chris Kobach, formerly legal counsel with the Immigration Law Reform Institute and now Kansas Secretary of State, readily admitted that the true goal behind those listed protections, so the true goal of the ordinances, is to have immigrants relocate or self-deport. It couldn't have been clearer. One of the most alarming aspects of anti-immigration ordinances is the belief that local police authorities can determine who may be legal and illegal without prejudice, discrimination, or racial profiling. Such a flawed assumption indicates a profound conviction that undocumented immigrants are illegal and criminals by their sole presence in the United States, something that the Constitution do not agree with, and that no constitutional provision of protection and due process should apply to those entering or being in the country illegally. So in the Lozano versus City of Hazleton case, Judge Munley was very clear, and he wrote, the Hazleton ordinances violate the procedural due process protection of the 14th Amendment. They penalize landlords, tenants, employers, and employees without providing them the procedural protections required by federal law, including notice and an opportunity to be heard. Our analysis applies to illegal aliens as well as to the legal residents and citizens. The United States Constitution provides due process and protection to all persons. And Munley even goes further in the conclusion of his 206-page ruling by suggesting that the crisis of perception of illegality experienced by Hazleton has no bearing on the constitutional provision of due process and equal protection when he states, and that's kind of an interesting quote there, whatever frustrations officials of the city of Hazleton may feel about the current state of federal immigration enforcement, the nature of the political system in the United States prohibits the city from enacting ordinances that disrupt a carefully drawn federal statutory scheme. Even if federal law did not conflict with Hazleton measures, the city could not enact the ordinances that violates rights the Constitution guaranteed to every person in the United States, whether local residents or not. Hazleton, in its zeal to control the presence of a group deemed undesirable, violates the right of such people as well as others within the community. Local politician obsession with illegal status was refuted by court's ruling, but nevertheless prevailed in sustaining and furthering an anti-illegal immigration sentiment. Such sentiment, openly criminalizing a vulnerable segment of the population, was supported by a strong current of populism, nativism, and neoconservatism in the United States, fed partly by mainstream and conservative media. Equating illegal immigration to public nuisance boosted the anti-immigration sentiment, instilled fear, and created the perception of urgency to do whatever is needed to control, deter, and remove unauthorized immigrants from community. The discriminatory motive underlying the ordinances was promoted by local politicians in the name of morality and patriotism, who seized political opportunities to fast-track their political ambitions and careers. Tapping into the discourses of security threat and economic scapegoating, the narrative of illegality and criminality continued to add confusion to the broken federal immigration policy discourse and the entanglement relationship of immigration enforcement. But from the legal end of the first generation of anti-illegal immigration ordinances evolve a more inferential rather than overt racism through the adoption of the second strain of nuisance laws, which I'm going to talk about now. In her legal studies work, Linda Nash in 2010 has reviewed 120 local immigration-related legislation and the subsequent enactment of nuisance laws. Controlling for the period of time when those laws were enacted and for the town's general legislative rate, she found that a strong correlation for 11 towns and counties and a significant correlation for 8 other towns and counties which had previously adopted some form of anti-illegal immigration ordinances. My interest is not so much in demonstrating that this is a wide trend, but rather to look at how these two strains of local ordinances, although separated, are nevertheless intertwined. What is particularly interesting is how, while nuisance laws are devoid of explicit reference to immigration, they have been used to target particular population, and in this case, to target immigrants and immigrant practices. Here, I'm just going to open a parenthesis to say that this part of the research is ongoing. We still need to do the empirical work of pouring into all the nuisance laws and all the police record and all the different complaints that might have been done. So what I'm going to present is more some kind of observations, basically. First, a little bit more on nuisance. Nuisance in common law is defined as a wrongful act that unreasonably annoys, inconveniences, discomforts, and damages public or private property. Legal scholars have described nuisance as being an impenetrable jungle, a legal garbage can, a catch-all litigation paradigm, the latest grab bag of jackpot justice. It is also said to be full of vagueness, uncertainty, and confusion, and notoriously contingent and unsummarizable. So quite a reputation. Nuisance has historically provided a flexible judicial tool to address conflict in land use and social welfare, for example, slaughterhouses, dumps, junkyards, and red light districts. Although more precise legislation has since supplanted the broad concept, local governments still use public nuisance as some sort of umbrella regulation to stop the conduct that something considered quasi-criminal because, although not strictly illegal, it is potentially harmful to the general public's peace, comfort, and morals. Nuisance laws are regulated through local police power, derived from a fundamental role of government, which is authorized by the 10th Amendment of the U.S. Constitution, in order to regulate public health, safety, and welfare. Municipal corporations have the right and responsibility to adopt regulation as to limit the uses and activities that either are considered nuisance per se or tend to become nuisance under certain conditions. Police power is said to be the most comprehensive of government powers, but also the vaguest, as the precise component and definition of the public health, safety, and welfare are far from being unanimous and fixed, but rather vary according to the social, economic, and political condition of a place. For example, overcrowding can be interpreted as nuisance, but such interpretation is not without a moral judgment on the ways of living of particular individuals or group. The problem with nuisance laws rests in its conceptual elasticity and its subjective nature, preventing specific noise such as construction, gardening, or music, or particular animals or vehicles, or graffiti, for example, is likely to affect and criminalize some people more than others. Thus, the determination of nuisance as a serious crime or as a simple annoyance is relative. Okay. Much of the ordinances seems to articulate a sentiment of fear about the perception and the potentials of immigration and immigrants to cause nuisance, but nuisance cannot be preemptive. The concept of nuisance itself cannot be preemptive. Nuisance deals with violation of common interests after they occur. So I should recognize that the concept of public nuisance is not completely hopeless. Public nuisance has been used in a more positive way, for example, by an environmental group, in the case of an industry or factory contaminating the air, the soil, the water of a neighborhood. In such case, neighbors can demand an injunction to halt the contamination or an abatement to repair some damages. But nuisance always requires proof of wrongdoing and its harmful consequences. So while the broad definition of nuisance makes it a convenient vehicle for imposing all sorts of restriction and shaping communities, it remains unclear to me how harm by so-called illegal immigrant to the public interest can be legally proven, given that for each study that consider immigration as a burden, you find at least one or two studies that will consider immigration as an asset, and especially given the reliance of many economic sectors on migrant laborers, for example. So, of course, in the eyes of the proponents of such ordinances, the harm and already obvious if we refer to the litany of stated problems created by illegal immigrants, and that's again the text of the ordinance. So the particular use of nuisance rhetoric in anti-immigration ordinances presume a series of perception presented but not evidence in the preamble section of the ordinances, because a lot of time the politician says, well, we don't need to evidence this anymore, this is common knowledge. So it's apparently common knowledge that illegal immigration leads to higher crime, subject our hospital to fiscal hardship, and legal residents to substandard quality of care, contributes to other burdens in public services, blah, 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 blah. So despite constitutional provisions, proponents of anti-immigration ordinances translate illegal presence in the country into criminal presence within their boundaries. They equate the presence of undocumented immigrants as an act of trespassing, as an intentional and wrongful invasion of municipal boundaries as public property. As perceived criminals, immigrants are seen as illegitimate members of local communities who are undeserving of protection and any social benefits. In the past, some anti-immigration ordinances have also attempted to control the presence of immigrants by using trespassing laws, but the courts have ruled that criminal trespassing charges were unconstitutional attempt at regulating immigration. Again, the specific use of trespassing laws was just another disingenuous strategy to regulate undesirable person or activities. And of course, all those undesirables should be in quotation marks. In nuisance laws, a moral judgment inherently qualifies particular ways of living as undesirable, and it is inescapably relational and conflictual in the sense that one is always undesirable in relation to someone else, diminished quality of life, aesthetic, or property value. It is said that, and I quote, "This misuse of public nuisance allow arrogant judges, politicians, and ambulance-chasing attorneys to create a system of social engineering and judicial legislation when they fail to get their way at the legislative level or in the free market of ideas." This aspect of nuisance laws as proxy for immigration control is the origin of local ordinances. The initial use of the concept of nuisance in immigration-related ordinances might actually be linked to the control of the laborers in an early and rejected ordinances in San Bernardino, California, prepared by Joseph Turner of Save Our State, and that was in 2006. The labor sites have long been deemed as local nuisance and crime areas, reminiscent of past attempts by local police to regulate disorder and enforcing criminalizing laws for vagrancy, loitering, panhandling, and homelessness through property regulation tools like zoning laws. The laborers are seen as a nuisance because, and here's a list of generally held perception by anti-immigrant activists, they litter, they wander, they trespass, they gamble, they fight, they drink, they urinate, they defecate, they use, and they sell drugs in public space. So they contend that the labor sites are areas where different levels of laws, so not just one level of laws, but different level of laws, are broken by immigrants. They cause traffic disturbance, they break employment law, they drive down wages, they use and traffic for the social security cards, they commit identity theft and tax fraud, they intimidate local residents, they occupy public sidewalks, and of course they inconvenience morals and annoy anti-immigrant sensibilities. That is why the neoconservative fair organization openly encourage people to file lawsuits based on public nuisance laws, to press local governments to enact an ordinance that prohibits all solicitation of moving vehicles, to encourage local businesses and residents to complain to police about the presence of the laborers, and it goes as far as to encourage residents to document curbside hiring violations. This is the anti-immigration vigilantism through the regulation of public space that is at the basis of local ordinances, the interior's version of border vigilantism. Goodness, okay, here we go. In his work on the control of misconduct in city spaces, Ellickson asserts that nuisance can only be created by act and not by status. He writes both classical liberal ideals in the Constitution demand that the law of street nuisances regulates a person's choice, not some unalterable status. In particular, it is impermissible to criminalize either the status of poverty or the status of homelessness. So I am neither a lawyer nor a legal scholar, but it seems like the pertinent question that arises from this observation is whether illegal immigration is an unalterable status. And here, the prospect of possible regularization is balanced against the lack of political will for such regularization. So I do not have an answer to that question. Rationalizing illegal immigration as nuisance is therefore highly problematic because it legitimizes a discriminatory public interest that criminalizes a particular group's status rather than their action. So not so much for any breach of local peace and safety, but rather for their mere presence in the urban setting. Illegal immigration as a whole is therefore formulated as public nuisance, a perceived aggravation and threat to the local quality of life and neighborhoods. Embedded in the illegal and the nuisance narratives are the explicit collective belief and affirmation of self-victimization, where members of a society are victimized by the presence of others, by the presence of illegals and criminals amongst them. In anti-immigration sentiment, and overtly and inferentially in the text of ordinances, the annoyance and menace of illegal immigrants legitimize arrest and deportation because undocumented immigrants are not authorized to be in the country. By using the concept of public nuisance, local advocates for tightening U.S. immigration laws evoke local police power to control, deter, repel immigrants from their jurisdiction. However, as Nicholas Rose reminds us, programs of crime controls have always had less to do with control of crimes than they had to do with more general concerns with the government of moral order. So in conclusion, I would say that immigrants, whether they are authorized or unauthorized, have often been perceived and blamed for the shortcoming of immigration policy. These shortcomings then legitimize the necessity for more immigration reforms and more immigration control. But as Coolidge argues, criminalization is a tactic in the war of immigrants. It is a form of social control that uses laws and legal culture to ostracize and control segments of the population through a myriad of techniques, including surveillance, biometrics, extending the reach of the criminal law, and using civil laws to help criminalize people. Such discourse therefore depicts immigrants as criminals who put the nation and the neighborhood at risk and consequently justify a range of deterrence measures, whether it be at the border, like wall construction, enforcement raids, or local nuisance laws, or all of the above. Local ordinances targeting direct policing of immigration and direct control strategies of immigrants have been one of the many ways to expand the securitization and the criminalization of immigration away from the border. In recent years, immigration laws enforcement have expanded from customs and border patrol agents to numerous untrained and unaccountable hands, such as detention officers, airline agents, staff officials, sheriff's deputies, and of course, local anti-immigrant politicians didn't want to be left out. One of the problems with this expanding outsourcing of immigration control from the federal level is that it creates this neoliberal allegory that a multitude of actors, from police to landlords to vigilante groups, need to step in and do their patriotic and responsible part to protect the national culture and sovereignty against immigration illegality. Where there might be a greater role for state and municipal government to play in the management of immigration, given the more direct contact with immigrants, piecemeal immigration policy inevitably accentuates the risk for harassment and reifies the idea that the immigration system is broken and therefore demands and rationalizes exceptional measures. So, whether we're talking about the overt racism in the first strain of anti-illegal immigration ordinances or the more insidious inferential racism contained in the second strain of local nuisance laws, local ordinances are not only politically dangerous and socially offensive, they circulate and normalize racist ideas about immigrants and translate them into vivid populist entitlements of domination over migrants. So local anti-immigration related regulation, in my view, quite clearly shows that immigration is not only about borders and sovereignty, but it is also very much about protecting privileges and domination through exclusion. Thank you.